Hello, I'm Tom Zuber. I'm the managing partner of Zuber Lawler, and welcome to today's webinar on the psychedelics program in Colorado. I am here with my colleagues, Raza Lawrence, Lizzie Fanckboner, and Ivy Perez-Bader, also of Zuber Lawler. We're very excited about this topic, and it's sort of a moment of truth for us. We've been looking forward to it for some time. First, a little bit about Zuber Lawler. For those of you who don't know us, we're a law firm that's blessed with attorneys across the country, and we do a lot of work in relation to, first of all, M&A and finance and real estate work, IP work, lots of regulatory work and litigation and investigations for some of the largest, most iconic companies on the planet, Fortune 500 companies, as well as government institutions and funds and family offices. But we also do a lot of work in emerging areas of industry and technology. It's where our hearts and our minds really have the most fun. And so that includes cannabis, it includes psychedelics, it includes plant medicines, legalized plant medicines of all sorts. And we've been following the progress on the psilocybin, the psychedelics, legalized psychedelics program in Colorado for some time. I would also like to say a few words about myself. I personally focus on intellectual property, but these days I do deals, I do litigation, as well as intellectual property for companies relating to matters around the world. I'd like to introduce first my colleague, Raza Lawrence, to say a few words about himself. Raza, do you want to go ahead and tell us a bit about you?
Yes. Hello, everyone. Thanks for listening to this presentation today. Very fascinating topic. Happy to be here. I've been representing people in the psychedelics industry for many years. Mostly my original legal work was criminal defense related because there were no legal avenues for commercial activity. I've done some work dealing with getting people set up in DEA licensed research studies, including with the universities. And now I'm excited to help with these new commercial opportunities that are opening up for the very first time in Oregon and now Colorado. I've also done a fair amount of work in the cannabis industry over the years. And as we'll discuss later, there are many parallels between cannabis and state licensed psilocybin, given that they're both Schedule I controlled substances under the Federal Controlled Substances Act. And there's all kinds of legal issues that come into play due to these conflicts of laws. But I've helped a lot of people in the cannabis industry transition from an unregulated market into a regulated market. I'm excited to be doing the same thing now for psilocybin. And we're happy to help at our firm with any legal compliance in connection with applying for licenses, any government enforcement actions, helping you navigate through those, developing contracts to set up your business, litigation, other forms of dispute resolution, and hopefully it doesn't come to this, but criminal defense as well. If you get charged with any criminal offenses or part of an investigation, we're always happy to help represent you in connection with that. So thanks, everyone. Happy to be here today.
Thanks, Raza. Lizzie Fanckboner, based in Colorado.
Hi, yes, I'm Lizzie Fanckboner. I'm an attorney here in Denver, Colorado. I'm also licensed to practice in Oregon. I focus primarily on corporate transactional matters, including M&A and finance, also licensing agreements and other deals. I've done a lot of regulatory compliance and have a lot of experience with work in the cannabis space. I worked for a number of years and still do with cannabis clients, whether they're dispensaries, manufacturers, cultivations, etc. And now legalized psychedelics as well. And I'm currently the chair of the Colorado Bar Association's Natural Medicine Committee, and happy to be here.
Thanks, Lizzie. And Ivy Bader, Perez-Bader.
Awesome, thanks. Hi, everyone. I'm Ivy Perez-Bader. I have a ton of experience in the cannabis licensing and compliance space. Originally, I started out in operations, and that was back in the Compassionate Use Care Act under California's medicinal regulatory scheme. And then also ran a cultivation facility that was licensed under a micro business. And that was under McCursa. And for the past 6 to 7 years, I've spent helping clients get licensed and stay compliant in a highly regulated market. and really, really excited to impart my experience and knowledge from cannabis over to the psilocybin space.
Thank you, Ivy.
Thanks.
So again, thank you very much for joining us. A very exciting topic, and I think a very exciting time. I'm going to turn it over to my colleague, Lizzie, to get us started, and she's going to start with a legal disclaimer. Lizzie.
Thanks, Tom. Before proceeding, this information provided during the presentation does not constitute legal advice. All information, content, materials provided during the presentation are for general informational purposes only. The views expressed by the panelists are personal views of the panelists and not necessarily those of Zuber Lawler. The panelists' views should not be considered legal or financial advice, and no attorney-client or other professional relationship is created. And now we can get on to the good stuff. This is just an overview of what we're going to cover today. So an overview of the Natural Medicine Health Act, the rules and upcoming applications, some local jurisdiction considerations, as well as industry overall considerations, and then what's next. So the Natural Medicine Health Act was passed by Colorado voters. It was Proposition 122. It was passed in the year 2022, and it created a state-regulated access program providing access to natural medicines for adults 21 years of age or older under the supervision of a licensed facilitator. It also provided for personal use of natural medicines. So right now, under the regulated program, the only natural medicine that will be available moving forward is psilocybin and psilocin. And then in 2026, we may expand the program to include DMT and mescaline. Ibogaine might come in a little bit sooner. It depends on if the Natural Medicine Advisory Board recommends that. And in 2023, the Colorado legislature passed Senate Bill 290, which basically outlined the formal implementation for Prop 122, and then a few additional tweaks in 2024 with Senate Bill 198. And I'll get into it, but there are actually three groups that are governing the program. So it's divided between the Department of Revenue, Natural Medicine Division, and the Department of Regulatory Agencies, which is DORA, as well as the Colorado Department of Public Health and Environment, CDPHE. So those are just where the statute and rules live. So just to lightly cover the personal use, which was part of the Natural Medicine Health Act, the personal use decriminalized several types of natural medicine, including psilocybin, psilocin, ibogaine, DMT, and mescaline, excluding peyote. Personal use is basically defined as the consumption of natural medicine or natural medicine products for those that are over 21. It also includes the amount of natural medicine or natural medicine product that a person may lawfully possess, cultivate, or manufacture that is necessary to share with another person who is also 21 or older in the context of counseling, spiritual guidance, beneficial community-based use and healing, supported use, and related services. So while natural medicines have been decriminalized, there are certain restrictions that remain in place, which includes the age limits. There are rules for where and how to cultivate, which I included a little bit on the slide. No underage access. There's no remuneration except as allowed. That's a little carve out for the law permits payments for bona fide harm reduction or support services used concurrently with sharing. There's some caveats with that as well, and then no open and public display. So the Natural Medicine Division, which is housed in the Department of Revenue, is in charge of licensing and regulating the natural medicine businesses. So those include the healing centers, cultivations, manufacturers, testing facilities, and then certain individual licenses, which is like an owner license or an employee would be licensed, a handler's license, which we'll discuss in a bit. And then the Department of Regulatory Agencies, DORA, license and regulates facilitators and also the facilitation training programs. Natural medicine services is defined as these sessions. So it's the preparation session, the administration session, and the integration session. Before those happen, a facilitator should really undertake an initial consultation and informal inquiry with the prospective participants. There's also some requirements to determine like a risk analysis. So the facilitator rules are quite robust in terms of making sure that they are meeting with the participant and that the participant will be able to safely use the natural medicine. So the preparation session is a critical first step in the natural medicine experience. It's between the facilitator and the participant, and it occurs before the administration session. During the preparation session, a licensed facilitator will meet with the participant to discuss their intentions and motivations, perhaps expectations and any concerns they may have in connection with the administration session. At this point, the facilitator also will need to provide relevant considerations or the prospective participant would need to know in order to make an informed decision about the moving forward and the natural medicine services, as well as the facilitator. And they also need to provide information about the effects of natural medicine, the potential risks, and a range of possible outcomes and effects. They'll go over disclosures and forms and consents. And here is also where they would discuss the appropriate use of touch during the administration session. So participants may consent to supportive touch, including by facilitators or someone else that's not the participant, but that needs to be outlined prior to the administration session. And so the administration session takes place at a licensed healing center or another statutorily allowed location under the supervision of a licensed facilitator. And this is where the participant consumes the natural medicine or natural medicine product and experiences its effects. In terms of doses and duration, for doses that are under 10 milligrams of total psilocin, an administration session can last no fewer than 3 hours, and until the participant is showing no obvious adverse effects from the natural medicine. For larger doses, between 10 and 50 milligrams, the duration is no fewer than 5 hours. And then there are group administration is allowed. There's a maximum ratio of 4 participants to 1 facilitator, and there can be no more than 64 participants max in a group session. And then so finally, we have the integration session, which is completed after the administration session. And the facilitator will then conduct a thorough review of the administration session. And they might discuss, insights, revelations, and other things that occurred during the administration session. Also, the facilitator must evaluate the participant and their reaction to the natural medicine or natural medicine product, and must recommend follow-up care and make referrals to other healthcare providers or facilitators as appropriate. The facilitator also cannot charge a separate fee for the first integration session, but they may recommend additional integration sessions. Okay, so regulated access program. These are the different license types. So there's the business licenses, which we went through, noting that the Healing Center has a standard and micro license, and a cultivation also has a standard tier and a micro tier. The individual held licenses are an owner's license and a natural medicine handler. So starting with just an overall restriction on the business licensing side, a person cannot have a financial interest in more than 5 natural medicine business licenses. And a financial interest is fairly broadly defined as an entitlement or agreement to receive a portion of revenue, proceeds, or profits from a natural medicine business or natural medicine business applicant. It also can include a membership interest, partnership interest, or other ownership interest in a natural medicine business. So for the Healing Center, as we discussed previously, that's where the natural medicine services will occur, and that's where the facilitator will work. So the two or could work. The 2 Healing Center licenses are the standard and micro, and the main difference between the two is that the standard has a more robust security requirements by the Natural Medicine Division rules. They must have a restricted access area, and there's a little bit higher license fees. The Micro Healing Center is really for those who are providing just a few services sort of as an ancillary to their main business, which could be something such as therapy. They can store up to 750 milligrams of psilocin. It must be stored in a locked place and monitored by video surveillance, but there's no restricted access area, and they don't have the robust security requirements that a standard Healing Center licensee would have for their licensed premises. In order to operate, a Healing Center must be owned by or contract with at least 1 facilitator, but there's no limit to the number of facilitators that can be associated with the Healing Center. The cultivation license for the standard tier and the micro tier, this is based on the amount of fruiting bodies that the cultivation can store, and some other differences such as the security requirements. But the standard can store up to 5 kilograms of dried fruiting bodies, and the micro tier is 750 grams of dried fruiting bodies. And also the micro license has less robust security requirements. At this time, a cultivator is only allowed to cultivate one species, which is similar to Oregon, which is Psilocybin cubensis, and synthetic analogs are not allowed. The manufacturing license, this is manufacturing regulated natural medicine products for transfer to a healing center, facilitator, or another natural medicine products manufacturer. This means that you can, just the basic license is manufacturing capsules or tea bags. If you have an extraction endorsement, then the manufacturer can manufacture chocolate, gelatin, some gummies, pressed tablets, or tinctures. There's regulations around what solvents can be used, water, food-grade ethanol, or food-grade oils, such as coconut oil. And there are also packaging and labeling requirements and serving size. So a single serving can contain no more than 10 milligrams of psilocin, and 50 milligrams is the total for a package, and 5 grams total for dried fruiting body per package. The testing facilities, a person that's an owner of a testing facility license cannot have a financial interest in any of the other businesses, so a healing center, a cultivation, or a manufacturer. And the testing facility must also be certified by the Colorado Department of Public Health and Environment. All of these business types must adhere to specific security requirements, as I mentioned, different for the micro versus the standard, and there's robust record keeping requirements. Co-location between the business licenses is allowed with some limitations. A healing center can be at the same licensed premises as the other license types and a healthcare facility, excluding the testing facility. A cultivation can be co-located with a healing center or manufacturer, and manufacturer can be co-located with a healing center, cultivation, or another manufacturer. There are restrictions about keeping products separate if you're co-located, and making sure your restricted access areas and administration areas are clearly defined. With regard to the healing center being co-located with the healing center, the restricted access areas cannot overlap with the administration areas. So there are additional rules related to that, but we'll move on to owner's licenses and natural medicine handler license. The owner's is for an individual or entity that owns or possesses or is entitled to a financial interest in a natural medicine business. It could be an individual or an entity. And then for the medicine handler's license, that is required for a person who is not an owner, but who has unrestricted access to regulated natural medicine or regulated natural medicine products. And this could be such as a person working at a healing center, if they would have access to the natural medicine or the products. If you have an owner's license, then you have all the same privileges as a natural medicine handler license, so you wouldn't need both. So the applications are going to be open December 31st of this year, so just in not much time, less than 2 weeks. The applications will be on forms provided by the Natural Medicine Division, but in terms of things that you may need to disclose, there's going to be ownership information, which would be the names of the owners and all the financial interests. If it's an entity, then it's the certificate of good standing, organizational documents, and all the owners, of that entity. You will need to include information about your licensed premises. So, for instance, a healing center can't be within 1,000 feet of a licensed child care center, preschool, elementary, junior high, high school, or residential child care facility. So you would need a diagram demonstrating that, whatever business is allowed in the local jurisdiction zoning or land use. So making sure that your location works. Having possession of the licensed premises, the facility. So having a lease, or if you own it, demonstrating ownership. Security information and diagrams. There's some tax documents, and also there is a ESG criteria, which I'll get into just a little bit. The tax documentation is basically proof that you have timely and compliantly filed returns and paid your taxes. There also may be some license specific information. So, for instance, for an extraction, you would have, a manufacturer, you'd have the extraction endorsement. One thing is, while these applications are not necessarily, they're not competitive and there's no cap on the number of applicants, the division, which is the Natural Medicine Division, may prioritize applications that identify one or more proposed owners with at least 51% ownership in the license who have a traditional, tribal, or an indigenous history with natural medicine, or one or more owners that are veterans, or the natural medicine business would be located in a county that's not in Adams, Arapahoe, Boulder, Denver, Douglas, El Paso, Jefferson, Larimer, Pueblo, and Weld, more of the populated areas. And then in terms of the ESG criteria, so applicants, as part of their application, must propose a strategic, measurable, achievable, real, and time-bound plan to incorporate principles of environmental resiliency or sustainability, including energy efficiency, the promotion of beneficial outcomes, and corporate governance. So they're noted on here as the environmental impact criteria, the social impact criteria, and governance criteria. And the rules, the Natural Medicine Division rules, provide options or examples of how to satisfy these criteria. And also just wanted to note that the plans will be made public. So for instance, for the environmental impact criteria, it could be employing sustainable agricultural practices or using sustainable packaging or sourcing energy from a renewable source. Social impact criteria could look like inclusive hiring and contracting practices and plans, providing a discounted or free services to historically underserved community members. And then for corporate governance, this could be making sure that your board or something akin to that for an LLC, like a board of managers, or is made up of members with diverse backgrounds and has gender equality. So like I said, the rules provide a list. So for this part of the application, it's helpful to go through that. So local jurisdictions cannot ban or prohibit the establishment or operations of healing centers. They can't adopt an ordinance or regulation that are unreasonable or in conflict with the Natural Medicine Health Act, but they can impose things such as zoning restrictions and enact certain ordinances in that regard. So there have been some activity with the local jurisdictions, and Parker, Castle Rock, Boulder, Denver, Golden, Alamosa City, Arapahoe County, Breckenridge have all had discussions about how, or enacted ordinances on how they're going to regulate time, place, manner of these natural medicine businesses. And I wanted to just highlight that Denver had several working group meetings to determine whether they were going to actually have like their own set of licensing. And it looks like they do have a proposal for City Council for January 2025, which would only require a local license for a healing center, but not for the other license types. It looks like they're really working to align their requirements with the state, but we'll see. So that's sort of up and coming. And so we'll just keep our eye on the local jurisdictions and see, where it's a big part of it to determine where you can actually have your business. So, and then moving over to DORA and the facilitator licenses. So a facilitator must be 21 years of age or older. They must have the necessary qualifications, training, experience, and knowledge to perform and supervise natural medicine services for a participant. And like I said, they are licensed by DORA, and the training programs are also approved by DORA. I'm going to cover the two main facilitator types, which is a facilitator and then a clinical facilitator. So a clinical facilitator can provide natural medicine services to participants for the purpose of treating physical or behavioral or mental health conditions. A clinical facilitator licensee must hold a current active license in Colorado. in a profession that authorizes them to diagnose or treat physical or behavioral health conditions. So this would be a psychologist, a licensed social worker, a licensed professional counselor, a doctor, a nurse practitioner, a physician's assistant. So those are all listed out in the rules. And they have a little bit of a different training requirement than the facilitator. So for the clinical facilitator, they need 150 hours of didactic instruction, 40 hours of supervised practicum training in the facilitation of natural medicine, and 50 hours of consultation. Whereas the facilitator license, they do need to complete the training program, both do, but they have 40 hours of supervised practicum training and 50 hours of consultation. Also for portability, so someone that's licensed in Oregon and that has gone through a training program for the Oregon program may apply to be licensed in Colorado as well. If they wanted to be licensed in Colorado for the clinical facilitator license, then they would also need to hold a Colorado license that authorizes them to diagnose and treat physical and behavioral mental health conditions. So they would have to have one of those other licenses. And there's also accelerated options. A facilitator, applicants for a facilitator who are former legacy healers may apply for licensure through an accelerated program. And some of the requirements for that would be providing facilitation for at least 40 participants with at least 200 hours of experience conducting administration sessions, and that the 200 hours of experience and the 40 participants must occur over the last 2 years. And so I think there's going to be some more information coming out from Dora about how the process for this. And then there's also an accelerated option for the clinical facilitator. And this is just a list of some of the training broken down. So currently right now, there are training programs can submit applications for authorization and approval from Dora. And these are some of the requirements of what their program would have to cover. I just wanted to note that the rules are fairly long. There's a couple hundred pages of rules at a minimum. So I did not cover everything, and there's a lot to cover, but in the interest of time to make sure that we can also discuss some of the other important considerations, I just kind of did a high-level overview. So I'll pass it on to Raza.
Hey, everyone. Thanks again for coming to our presentation. I'm going to get into some of the legal challenges that businesses face in this industry, some unique issues that come up with the federal illegality combined with the state licensing, and kind of how you should think about operating in this new legal environment that's opening up. So first of all, just how to think about navigating these complex regulations. We have several layers of laws, sometimes conflicting with one another. You have the local jurisdiction laws at the city and county level that can regulate a lot of details about how a business operates. You have the state laws, which are now putting out these licenses for the first time. And you have the federal law, which makes the commercial psilocybin completely illegal, other than for certain limited research studies. In terms of the state level, we've got really three main agencies that are involved. There's the Department of Regulatory Agencies, primarily oversees the licensing and facility operations. You have the Department of Revenue, which is doing tax compliance and financial regulations. And then you have the Colorado Department of Public Health and Environment with such safety standards and public health protocols. Then at the local level, the local jurisdictions are allowed to set time, place, and manner restrictions that can add another layer of complexity and limit potentially where and how the healing centers can operate. It's important in this process at the local level, right off the bat, to engage with local authorities, understand the municipal zoning laws. Sometimes there's different permits you might need to get at the local level based on land use rules and zoning. So it's important to get a handle on that and just start talking to the local politicians to make sure that you won't face any problems going forward with them. Then at the federal level, there's also various agencies that could be involved. It starts with the DEA, the Drug Enforcement Administration. It maintains psilocybin Schedule I classification under the Controlled Substances Act, and it enforces federal drug laws and regulations in connection with the Federal Department of Justice. the Federal Department of Justice sets federal enforcement priorities. Basically, they could decide to come in and start prosecuting people in the psilocybin industry, even the state license industry, if they wanted to. We'll hear a little bit more later about how in cannabis they've held back on federal enforcement when businesses are complying with state laws. But people in this industry are going to have to pay attention to the DOJ, and if they start enforcement actions in certain areas, it's important to monitor that. Also, at the federal level, we have the FDA, the Food and Drug Administration. Again, they're not going to really regulate psilocybin directly because it's illegal at the federal level, but they have certain guidelines about product labeling and marketing and so forth. And it's good to try to comply as much as possible with the FDA regulations. Then, of course, at the federal level, you've got the IRS that enforces federal Section 280E limitations. Psilocybin businesses, like cannabis businesses, because they sell traffic in Schedule 1 controlled substances, as it says in 280E, they're not allowed to deduct for expenses. So we'll get into a little bit about that shortly, about strategies for dealing with that. You also, at the federal level, have the Financial Crimes Enforcement Network, part of the Department of Treasury, and they issued guidance on banking services. They've issued a set of guidelines for when and how banks can deal with cannabis businesses that will likely apply to psilocybin as well because of the legal parallels, but that they're going to impact whether you're going to be able to get a bank account for your business and how the dealings with your bank might work. So these are the different federal agencies. There's different federal laws that can come into play. The Controlled Substances Act, which sets psilocybin at Schedule 1. There's the Federal Food, Drug, and Cosmetic Act, which has certain labeling requirements and marketing requirements. The banking regulations, federal employment laws will apply to people in the cannabis industry. So it's important to do the psilocybin industry. It's important to do employment law compliance off the bat, have an employment handbook and so forth, make sure you're complying with both the federal and the state employment laws. And then, like we said, the federal tax laws as well. So because this state licensed industry is new, we're going to have to see how the federal state interactions play out, what the enforcement priorities are going to be at the federal level, and coordinating with local law enforcement, and how these conflicting requirements of the federal and state regulations are going to play out. Also, at the federal level, there is limited activity that people can do in compliance with federal law. It involves research studies with the DEA and potentially drug trials with the FDA. And it's open what will happen at the federal level if it's going to be rescheduled. If it moves to Schedule 2 or Schedule 3, then it'll be legally allowed just for medical purposes with a medical prescription, or the feds could deschedule psilocybin, meaning it's totally up to the states to regulate. So we'll have to see where things go for now. Currently, if you want to be federally legal, there's only certain limited research programs you can do. So parallels with the cannabis industry, there's no protection under federal law. Cannabis had something called the Cole Memo that had guidance on federal enforcement priorities. Basically, if businesses are complying with state law, the feds are generally not going to intervene except in certain specific instances where there's certain sort of red flags. If there's cannabis, psilocybin crossing state lines, involvement in organized crime, and so forth. The other difference between psilocybin and cannabis is psilocybin in Colorado, it's a therapeutic only model. So this isn't exactly a medical model. You don't need a doctor's recommendation. It's open to all grown-ups, but you're not allowed to just go and purchase psilocybin from a dispensary and take it home. It's designed to have it in a controlled, supervised environment for wellness, healing, and therapeutic services, rather than as a retail product for unsupervised use. But again, no doctor's recommendation is required. That could change if at the federal level, if it gets rescheduled and it goes into a medical model at the federal side. promoting public safety and education. There's a lot of stigma about psychedelics after decades of sort of propaganda from federal drug authorities, and people have been grown up hearing that this isn't good for any purposes and it's highly dangerous. Attitudes are changing, so we're starting to see public opinion shifting, but the industry will have to do better about communicating and making people comfortable. Okay, pioneering therapeutic services. This is the first time that it's legal. We're starting with Oregon, but now Colorado, in terms of providing these services and kind of developing a good model, a structured treatment protocol. This is a new field, so people will need to get a protocol for initial screening, preparation sessions, supervised administration, integration support, and having quality control in their operations, standardized procedures, documentation requirements, tracking outcomes, and best practices for development. So there's a lot of room to distinguish yourself in these areas since it's a new industry, and the businesses that get this right will have the most potential for growth and potentially expanding nationwide as the laws open up in other states and potentially at the federal level. So economic growth potential, this is a new industry, so there's a potential advantage for the first movers, the people who come in there, establish their brands, capture the early market share, set standards for the industry, and again, could be ready to expand as the laws open up. And mental health treatment innovation. There's a lot of public awareness now about how this can help with mental health issues. There's federally approved research trials showing psilocybin has led to improvements in major depressive order, and how things play out in Colorado, could help pave the way to establish this as a proven mental health treatment that's more widely accepted. The federal illegality. So as we've discussed, Colorado is opening up the production and sale of psilocybin under state law, but it remains illegal under federal law, Schedule I controlled substance, and it's actually pretty severe criminal penalties at the federal level. So it's important to keep in mind the federal illegality and how to avoid federal enforcement. Colorado is the second state after Oregon to license federally illegal psychedelics, so it's sort of testing the waters for other states looking at psychedelic legalization. Under the Supremacy Clause of the U.S. Constitution, when there's a conflict between federal and state laws, the federal law essentially trumps state law, and the federal law controls. So the feds can come in and enforce the federal law whenever they want to. But again, as we've seen in cannabis, hopefully they won't come in and interfere with businesses that are complying with state law. But if you don't comply with state law, then you go into the category where you might open yourself up to federal enforcement as well, and those penalties can be quite severe. There's a case that went all the way to the U.S. Supreme Court, Gonzalez versus Raich in cannabis, where they challenged the Fed's ability to come in and interfere with people who are only doing intrastate activities. But basically, the Supreme Court said there, as long as your activity has some substantial effect on interstate commerce, which it turns out can be almost anything, the feds can come in and enforce the federal law. So we have that kind of looming in the background, and it's important to stay abreast of the federal enforcement priorities and patterns to stay out of those crosshairs. If you focus on having a good compliance program under state law, having your state license, hopefully you should be in good shape. But there's no formal legal protection like there is under federal law for cannabis. There's something called the Rohrabacher-Farr Amendment that's been in place for the last decade that's protected certain medical businesses complying with state law. There's no formal protection for psilocybin businesses. So it's important to just keep an eye out about what's going on at the federal level. Again, there's the Cole memo that's come out that's given some enforcement priorities. It would be advisable to comply with those if you're in psilocybin as well. Avoid things like allowing access to minors, using revenues from the business to finance criminal enterprises, diversion of psilocybin into other states where it's illegal under state law, combining the psilocybin with other types of criminal conduct, any kind of violence, of course, could be a red flag, or any activities on public lands that are controlled at the federal level. We don't really know what's going to happen with this new administration. It's sort of anyone's guess. In the past, Trump has been kind of strict in terms of some compliance with controlled substances law, but with RFK Jr. coming in, He has said that he thinks that he's pledged to deschedule Ibogaine and all psychedelic medicine. But this was before he joined up with Trump, but it seems like RFK has said, he wants to expand access to psychedelics, and perhaps this new administration will be friendly to the industry, especially if people are complying with state law. But these next few months will be important to kind of monitor what's going on at the federal level, because we just don't know what this new administration, what tactic they'll take. So certain issues that have come up with in the cannabis industry, they're going to come up with with psilocybin as well. The federal illegality affects all aspects of operations. There's no bankruptcy protection because it's illegal under federal law. But they can go into receiverships. There's other options for financially challenged businesses. There's limited access to federal courts for contract disputes. You definitely want to stay away from interstate activity. That's something that can get the feds interested. So definitely keep your operations within the state of Colorado for now. Banking challenges. A lot of banks have been very reluctant to provide traditional services to cannabis businesses because of the federal illegality. They don't want the feds coming in and charging the banks with criminal violations for aiding and abetting violations of federal laws. They don't want to have their assets seized by the feds under asset forfeiture laws. There's some guidance that was put out by FinCEN, the federal regulatory body that issues guidance for banks back in 2014. It explains how banks can provide services to cannabis clients that are complying with state law. It's likely that banks will start to follow these same principles for psilocybin, although there's no official federal guidance. But it remains to be seen how much access psilocybin businesses will have to banks. But there's a framework from cannabis that'll allow them to do that. Taxes, 280E, we've talked about how people are running a business that traffics in Schedule I psychedelics. They are not allowed to take deductions, a lot of deductions, so they end up paying a lot higher taxes. There are certain strategies that companies can do to avoid the severity of the law. Some of it is maximizing the amount of income that can be attributed to cost of goods sold, like the cost of the psilocybin and the transportation used in acquiring it. These are allowed to be deducted from taxable income, unlike other expenses. Also setting up separate entities that can be used that don't directly buy and sell the psilocybin, but those can be not subject to 280E. So, for example, owning the intellectual property associated with the business, owning the real estate, subleasing portions of the premises to non-trafficking activities, and having everything that's not directly involved in the buying and selling spun off into separate businesses that are not subject to 280E. Insurance. There could be difficulties obtaining insurance since it's a new industry. There's liability concerns about people using psilocybin and committing various types of misconduct. But in cannabis, there were certain insurance companies that specialize in this area. I think we'll see that with psilocybin as well. But it'll be important to find those specialized carriers that are willing to work with people in this industry. Also, federal law, there's property and lease issues. A lot of times landlords are skeptical of leasing to federally illegal business because they're worried it could result in a cancellation of their mortgage, a criminal case against the landlord, or asset forfeiture. So working with property owners can be a challenge, and it's important to, make sure early on that if you're going to be leasing property, that the property owner understands these issues and are comfortable with them. Also, trademark issues. You're not allowed to trademark at the federal level a product that violates federal law. You can trademark at the federal level ancillary businesses. So it's possible that, you could get a federal trademark for providing certain types of services that are not directly involving buying and selling psilocybin. At the state level, you can trademark. So that's something to look at, trademarking a brand name with the state of Colorado that'll at least protect you within the state limits. So what's happening now, December 31st, less than 2 weeks away, they're going to be opening up for the different types of activities. You can apply for healing center license, cultivation facilities, manufacturing facilities, testing facilities, and facilitator occupational licenses. I believe the state said that they're hoping the first businesses could start operating by March, so it's going to start moving quickly. If you're thinking about applying, getting in on this early round of applications, the first step is form a business entity, draft agreements between the owners, operating agreements, preparing the corporate governance documents, getting your initial funding. Getting loans can be difficult in this industry with the federal illegality. So, coming up with a plan to finance your startup costs, setting up your 280E tax compliance, how to structure it to minimize the 280E burdens. And then the location planning, finding a location where the local government's going to be fine with is, step number one. And talking with your local governments and, understanding what the process is at the local level. I've seen in cannabis, sometimes the zoning can be so restrictive that there's only, in one case, it was only one property in the whole town met the zoning requirements for cannabis. So there's likely to be similar restrictions at the local level for psilocybin. And it's important to figure that out off the bat, because if you don't have a location, you're not able to have a business. Other than that, once you get these basic nuts and bolts, coming up with a business plan, creating plans for expansion as this opens up. There's going to be other categories starting in 2026, other natural medicines, thinking about how you can integrate those, and coming up with a plan to possibly expand into other states, nationwide as these laws change. It's happening pretty quickly. And there will be a lot of opportunities for the companies that think strategically about how to set this up. So I will wrap up this section here, and I wanted to pass it along to Ivy now to speak for a little bit.
All right, thanks. So what I would really like to do is give our guests some good nuggets that they can take away. Raza, you talked about this a little bit earlier, which was location. So there generally is highly restrictive zoning. Location. That is probably the number one thing I see go wrong in cannabis projects. So get ahead of that as much as you can. That's super important. Also, community is super important as well. And I'm not just talking about your neighbors, which are incredibly important because they're going to be the ones showing up at the public hearings. They're going to be the ones making the comments. I have gone with some of my clients and we've done neighborhood outreach where we were knocking on each and every door in that neighborhood and providing them things like our odor control plan, right? Because that's a huge thing in cannabis. Ensuring that the odors don't rise to a level of nuisance. It's very important. It's very important to your neighbors. So get on good terms with your neighbors, number one. And number two, talk to your public officials, city council members, very important. Anyone who's a decision maker. Also anyone who's on the planning committee, the planning commissions, anyone who is going to be, part and parcel of making rules about property is very, very important to reach out to. And it absolutely makes a difference. Also, Raza talked about this as well. The issue of the federal illegality is huge. So what you want to do is ensure that you have a plan in place just in case the feds decide to come knocking at your door. One of the very first things I did when I was operating under the California Medicinal Rules, Prop 215, which was later codified to the Compassionate Use Act, was to create a civil asset forfeiture reduction policy where we minimized any risk associated. So I hope those nuggets of information really help our guests in the future, and I'm really looking forward to the opportunity that the psychedelic space is going to provide to us. And with that, I'll yield.
Thank you for joining our presentation.
Yeah, I just wanted to say if anyone's interested in possibly setting up a business, trying to take advantage of these new laws, just reach out to any of us. We could set up a consultation to just talk about what you're looking to do, what the options are, how we could help you move forward. But this is an exciting time in the world, and we're happy to be helping people navigate through this new legal system.
All right. Thanks, everyone. Take care.
Thank you all.